Good day to Madam Norazan. My name is Shalin Angchalin and this is my group members, which is Linda, Azim, Sophia, and Ainul. In this presentation, we will be discuss several contractual disputes which involve unilateral offer versus invitation to trade, privity of contract, intention to create legal relations, liquidated damages versus penalty, and counter offer and termination of offer. For my part, I will be discuss the first issue, which is whether the advertisement by Chapasi Hassan Berhad constitute an unilateral offer or merely an invitation to trade, and whether Ida is entitled to RM 10,000 reward. In this case, Chapasi Hassan Berhad released a nationwide advertisement for its product, Immune Patch, and promised RM 10,000 reward for users who use the product daily for 30 days as directed and still develop severe skin allergy. And the company claimed that RM 100,000 deposited with June Bank to prove the company's sincerity. Relying on this advertisement, Ida, a nurse, followed all instructions but still developed allergic rash within 3 weeks. Company refused payment when Ida demanded the RM 10,000 reward. Chapasehat Sandram Berhad claiming that the advertisement was merely a promotional gimmick and no intention to be legally bound. The relevant law can be applied in this case will be Section 8 of Contract Act 1950, whereby acceptance of an offer may be made by performing specific conditions of proposal, and in unilateral contracts, acceptance does not require communication but is completed through performance. The leading authority for this issue will be Carlyle and Public Smokeball. The defendant advertised that they would pay £100 to anyone who used their product as directed and still contracted influenza. And the company even stated that money had been deposited in the bank to show sincerity. The court held that the advertisement was not an ITT but an unilateral offer to the world at large, could be accepted by anyone who fulfilled the conditions stated. Applying the law to the present facts, the advertisement by Chapasi Hassan Berhad bears a strong resemblance to the advertisement in Carlo case. Firstly, the advertisement contains clear and definite terms. It specifies the reward amount of RM 10,000, the condition of using the Immune Patch daily for 30 days, and the result of still developing a severe skin allergy. Secondly, the company's statement that RM 100,000 had been deposited with June Bank strongly indicates an intention to create legal relations. It mirrors the fact in Carlyle cases where the deposit was seen as evidence of sincerity rather than mere sales puff. Thirdly, Ida clearly accepted the offer through performance as recognized under Section 8 of Contract Act 1950. She purchased the Immune Patch and followed all the instructions as required. It really no need for her to notify Chapasi Hassan Berhad of acceptance beforehand. Acceptance of unilateral contracts is completed once the condition had been fulfilled. From Ida's perspective, all elements of a valid unilateral contract are present. A clear offer, acceptance by performance, consideration in the form of purchasing, using the product, and the intention to create legal relations. From the company's perspective, it may argue that the advertisement was merely promotional gimmick. It lacked intention to be legally bound. However, this argument will be weak due to the inclusion of the bank deposit demonstrates seriousness and goes beyond mere advertising path. In conclusion, the advertisement by Chapasi Hassan Berhad is an unilateral offer rather than an invitation to trade. By relying on Section 8 of Contract Act 1950 and the precedent set in Carlyle case, Ida validly accepted the offer through performance. Chapasehat's refusal to pay on the ground that advertisement was a gimmick is legally unfounded. Ida is entitled to claim the RM 10,000 reward. Chapasehat Sandra Berhad is legally obligated to honor its promise. That's all from me, and now I will pass the floor to Linda.
Thank you, Charlene. Now I will continue with the issue whether the doctrine of privity of contract permit Hafiz and Ida as third party to enforce the contract entered into with Rahman and Johan. The fact of this case is that Ida's father Rahman had entered into an agreement with Hafiz's father Johan. Both of them agreed that if their children married each other, each father would give 50,000 to the couple as a wedding gift. After the marriage took place, Rahman had fulfilled his promise However, Johan died before making the payment. Hafiz and Ida tried to claim the money from Johan's estate, but Johan executed rejected their claim because both of them were not parties to the contract. What are the relevant laws applied in this case? The Contract Act 1950 is silent on the doctrine of privacy. In Section 2, subsection D allows consideration to move from a person other than the promisee, but this does not affect the law as to whether a stranger to a contract can enforce it. The court, in the case of Kepung Prospective Limited and Schmidt, the court have ruled that while Section 2, subsection D allow a third party to pay or provide consideration, it does not give them the right to sue. The case law that applies to this issue is that first, Swedel and Atkinson; second, Kepung Prospective Limited and Schmidt; third, Puncak Classic Sdn Bhd and fourth, Chong and Sons Sdn Bhd. What are the general rules in the privacy of contract? The law has laid down the principle that only those who are third parties to the contract or privy to the contract can sue or be sued on it. A person who is not a party to a contract may not enforce the contract, even though it was made for his or her benefit. Furthermore, the parties to a contract cannot impose liability upon a third party who is a stranger to the original contract. The doctrine of privacy of contract prevents the attempt by the parties to the contract to confer benefit on third parties who are strangers to the contract. As in the situation of Hafiz and Ida, they were a stranger to the contract between Rahman and Johan, even though they are the children of the contracting parties. The established rule is that Hafiz and Ida cannot recover because they are not privy to the contract, even though they are the beneficiaries of the contract. We can see in the case of Puncak Classic Sdn Bhd and Chong and Sons, where the Court of Appeal held as follows. The doctrine of privacy of contract is well known. It provides that only parties to a contract can enjoy the benefit of the contract or suffer the burden of it. Consideration must flow or move from the promise. A person cannot simply sue on the contract if the consideration is provided by the others, even where the contract is made on his benefit. Thus, the court reiterated that a person cannot sue on a contract if the consideration was provided by another, even if the agreement was designed to benefit them. As the principle laid down in the landmark case for privacy of contract in Swedel and Atkinson, the court rejected the groom claims. It was held that the groom was not a part of the agreement between the fathers, and he did not provide any consideration for the promise made by the fathers of the bride. Also, as a stranger to the contract, the son could not enforce it. On this basis, the court found in favor of the executor of the wills. Therefore, if we apply the laid down principle in this case to the situation of Hafiz and Ida, both of them whom a stranger to the consideration, and therefore they cannot sue on a contract, even if the contract was made specifically for their benefits. The only party that is eligible to take action is Rahman, who is privy to the contract. While Hafiz and Ida, a stranger to the contract, they cannot sue due to the privacy of contract. Rahman does not encounter this issue because he is a party to the contract and he is still alive. Hafiz and Ida may take action to Rahman. However, the legal action must be initiated by Rahman himself, who has the legal standing on this case, not their children. Unlike Hafiz and Ida, Rahman is a signatory and a dry right party to the agreement. He provided consideration, his own promise to pay 50,000 in exchange for Johan's promise. Therefore, the contract is valid and enforceable between them. However, the court will look into the facts that whether that party, which is Rahman, has suffered any actual loss as a result of Johan's breach of contract. Therefore, although Rahman had standings to sue as a contracting parties, the court will examine whether he suffered any loss as the payment was intended for Hafiz and Aida and not Rahman. Thus, no actual loss was incurred. Therefore, based on the argument provided, and by applying the doctrine of privity of contract, Hafiz and Aida are not entitled to claim from Johan Estate as they are not parties to the contract, even though they are beneficiaries of the contract. Thank you. Now I shall pass the floor to Azim.
Hi everyone, my name is Muhammad Azim bin Zahid, and today I will be presenting the third issue, which is whether there was an agreement to create legal relation between Aida and her mother. If the agreement was a domestic agreement that is not legally binding. So facts of this issue is the first one, Aida, who is struggling financially, accepted her mother offer to leave her nursing job and study law full-time. In return, her mother promised her to provide 2,000 ringgit allowance per month until she graduated. After a disagreement between Aida and her mother stopped paying the allowance to Aida, insisting that such family arrangement was not a contract. So I'm using the case of Jules and Badavaton. In this case, a mother promised her daughter a monthly allowance and gave her house for her to live while she is studying for the bar in England. Years had passed, but the daughter still had not completed her study, and a dispute arose when the mother wanted to reclaim the house. So the court held that such arrangement was a domestic arrangement between family members, and there was no evidence to rebut this presumption. So this case established one principle, which is family members' arrangement depend on good faith principle and not legal enforcement. So my application is both Miss Ruby Padavaton and Aida were promised a monthly allowance from their mother if they study law, and the monthly allowance stopped after disagreement happened between their mother. Ruby's argument, which is her mother promise was legally binding because he had given consideration by giving up her job and his life was and her job and her life was not true, because the court assumed that such family arrangement was a domestic arrangement between family members, and there was no evidence to rebut this presumption in the previous case. Aida can also use argument that Ruby's argument will state that Aida had to leave her nursing job and continue to study law under her mother's pursuit. But Aida's situation will likely be the same as Ruby's situation unless Aida can prove that he had any evidence to rebut this presumption. So my conclusion is Aida will definitely lose the lawsuit if she sue her mother, unless she can provide an evidence that rebut this presumption of domestic arrangement between family members. Thus, I will give advice to all parties, which is advice to the mother, which is Aida mother, and advice to Aida. So the first one is Aida mother is advised to argue that she is simply arguing that she is supporting her daughter's education out of natural love and affection, and her agreement between Aida not a business contract. On the other hand, Aida is advised to rebut this presumption of domestic arrangement between family members and provide an evidence that shows her arrangement was a serious business arrangement between her and her mother.
My name is Sophia Hani, and I will be presenting the fourth issue, which is whether the requirement to repay the entire bond amount is valid liquidated damage clause or an unenforceable penalty. The facts in this issue is that after Ida completed with her studies, she entered into a scholarship agreement with the Ministry of Health (MOH) for 5 years. However, Ida then decided to resign because she wanted to work overseas after only serving for 2 years, constituting a breach of contract. Because of this, the Ministry of Health demanded the repayment of the full amount of the bond from Ida because of the breach. But Ida argued that this term is unfair and is an unenforceable penalty. In order to answer this issue, we will have to look at the relevant laws, which include provisions and also case law. Firstly is Section 75 of Contract Act 1950, which is the general rule that states in any event of breach of contract, the party that complained for the breach is entitled to a reasonable compensation whether or not an actual loss is proven. However, there is an extension for a scholarship agreement under Section 5, subsection A of Contract Amendment Act, which state that if there's a specific sum that was mentioned in the agreement or agreed to in the contract, then the whole amount should be paid. And the third one is the case of University of Malaya and Lee Min Chong, 1986, 2 MLJ 148, and also the case of Government of Malaysia and Thelma Fernandez and another, 1967, 1 MLJ 194. In the case of University Malaya and Lee Min Chong, Lee had entered into a scholarship agreement to serve the university for 5 years after he had completed his studies at Canada. However, Lee only served the university for 2.5 years and then he resigned without their consent, which constitute a breach of contract. Because of this breach, the university then brought an action against him for the sum of 5,000. But Lee argued that this is not valid because there was no consideration from the university. However, it was true that the university is entitled to the sum because they had provided enough consideration for the promise by funding for his studies. Next, in the case of Government of Malaysia and Thelma Fernandez and another, 1967, a scholar was bonded under a scholarship agreement to serve at the Malayan Teacher Training College for 5 years. However, the scholar only served for 2.5 years, therefore breaching the contract. In this case, it was held that the scholarship authority could recover all of the costs that they had expended throughout the course of the training. It was stated that the amount that was claimed is not a penalty, but instead a need to preserve the interest of the government in carrying its educational policy. Moving on to the applications. So Ida had failed to complete her agreed service period of 5 years with the Ministry of Health. This constitute a breach of contract similarly to the case of University of Malaya and Lee Min Chong and the case of Government of Malaysia and Thelma Fernandez. Ministry of Health had funded Ida during the period of the 2 years of her service, which is providing a valid consideration to the promise. This made them entitled in order to claim for the breach of contract against Ida. In addition, to pay the full amount of bond is not a penalty, as established in the case of Government of Malaysia and Thelma Fernandez, because by claiming the full repayment of the bond, Ministry of Health is only trying to preserve the policy of education and to recover the public funds that they had already spent on Ida, and also to find her replacement after her resignation. Next, in case of breach, according to Section 75 of the Contract Act 1950, which is the general rule, is that any authority that claims for the breach is entitled to only a reasonable compensation. However, there is an extension for a breach of contract under a scholarship agreement, which falls under Section 5, subsection A of Contract Amendment Act, which states that if there's any specific amount to the agreement, then the whole amount should be paid. And in this situation, Ministry of Health demanded for a full repayment of the bond from Ida. And in this case, the entire amount of the bond can be considered as a fixed term from Section 5, subsection A, which mean Any amount that was agreed to in the scholarship agreement between IDA and the Ministry of Health is the amount that can be claimed and paid for. In conclusion, the requirement for IDA to repay the full amount of the bond is valid and is a liquidated damage instead of an unenforceable penalty. Therefore, the Ministry of Health can claim the full amount of the bond from IDA because it is reasonable to recover public funds and find replacement offer, and also important to preserve the interest of government in carrying its educational policy. However, if IDA wishes to appeal, she can argue that the full repayment of the bond is unfair because she only served for 2 years out of the 5 years. That concludes my presentation for issue 4. I will pass the floor to Ainu.
My name is Anumadiha and I will presenting the last issue. The last issue is whether either counter offer of 450,000 ringgit terminate Lala original offer of 500,000 ringgit and whether a valid contract was formed when either later accept the original price. The facts under this issue is Laila offered to sell the house to Ida for 500,000 ringgit. Ida did not accept and instead made a counter offer of 450,000 ringgit. Laila rejected the counter offer. A few days later, Laila wrote back agreeing to buy at the 500,000 ringgit. Laila refused, stating that the original offer was no longer valid. Under the case of height and range, defendant wanted to sell the farm to the plaintiff for $1,000. Plaintiff counteroffered to buy the farm for $950. However, the defendant rejected the offer and the plaintiff later expressed a desire to accept the original $1,000 offer. The court ruled that no binding contract had been formed because the plaintiff did not accept the $1,000 offer unconditionally and instead made a counteroffer of $950. By doing so, the original offer is terminated and cannot be revived later by accepting the original price. As seen on the case of height and range, the counteroffer acts as the rejections of the original offer. Counteroffer occurs when the offeree of an offer responds with a new set of terms or a different price. Secondly, terminations of offer. Terminations of offer occur when an offer is rejected or a counteroffer is made. The original offer will be cancelled unless the offeror reissues the offer. Applications under the issue. Laila initially offered to sell the house for 500,000 ringgit and Ida did not accept this offer but instead responded with an offer to buy it for 450,000 ringgit, which is counteroffer. By making this counteroffer, Ida legally rejects and terminates Laila's original offer of 500,000 ringgit. Laila's refuse of the 450,000 ringgit counteroffer confirms that there were no agreement at this stage. When Ida then agreed to buy at the price of 500,000 ringgit, there were no offer left to be accepted because the counteroffer had terminated Laila's original offer. Therefore, no contract was formed and Laila has the right to refuse to sell to Ida. In conclusions, Ida counteroffer of 450,000 ringgit terminates Laila original offer of 500,000 ringgit. No valid contract was formed when Ida then tried to accept the original price because no offer still exists to be accepted. Advice to Ida should advise Laila to make a new offer or renegotiate the price as she cannot rely on the previous offer to legally bind Laila. That's all from us. Thank you.